All right, here's where things stand. The last time you heard from me, the federal lawsuit had not yet been filed. It has now been filed, and it was accepted by the United States District Court for the District of Minnesota. That means the complaint cleared intake, the case was opened, a federal judge was assigned, a docket was created. This is no longer theory, it is active federal litigation. After filing, the next step was service of process. The court ordered that the United States Marshals handle service. There were service issues at the outset. That happens. Service is procedural. It has to be done correctly, and sometimes it takes more than one attempt. The court addressed it, reservice was ordered, reservice was completed. The defendants were properly served and formally brought into the case. Once properly served, the defense responded the way government defendants almost always respond in civil rights cases. They did not file an answer. They filed a motion to dismiss under Rule 12b-6. That motion argues something very specific. It does not argue the facts. It does not argue evidence. It argues that even if everything in the complaint were assumed to be true, the plaintiff has not stated a legally viable claim. It's an attempt to end the case before discovery ever begins. I filed a memorandum in opposition, structured, cited, directly addressing their arguments. After that, the defense filed a second motion to dismiss, more developed, more aggressive, expanding on their legal theories. Again, this is standard litigation strategy. At the motion to dismiss stage, government defendants push hard. They raise qualified immunity. They raise technical arguments. They argue failure to state a claim. They argue that relief is unavailable. The goal is simple: stop the case before the court ever reaches the evidence. I responded again, another memorandum in opposition. Then they filed a reply. I supplemented where appropriate. And then I filed an amended complaint. That matters. An amended complaint sharpens the allegations. It clarifies constitutional claims. It strengthens legal framing. It removes ambiguity. It ensures the court is evaluating the strongest, most precise version of the case. Amendment is not retreat. It is refinement. So here is the current posture of the case. The federal complaint has been filed and accepted. The United States Marshals were ordered to serve. Service issues were addressed. The defendants were properly served. Motions to dismiss have been filed. Oppositions have been filed. Replies have been filed. Supplemental briefing has occurred. An amended complaint is now on the docket. Everything is documented. Everything is public record. The case now sits before the court awaiting a ruling on dismissal. That ruling determines the next phase. If the court grants dismissal, the case narrows or ends. If the court denies dismissal in whole or in part, the case proceeds into discovery. And discovery is where litigation changes character. Discovery means compelled production of documents. It means depositions under oath. It means internal communications become relevant. It means the case moves from argument to exposure. For now, we wait. The case is active. The defendants are in. The briefing is complete, and when the court rules, you will know. We stand for justice and accountability.